So welcome. We are now on question 2. This is still CPA foundation level, CS foundation level, CCP foundation level, and it's an August 2022 paper. We are revising this so that you can see how to go about answering the questions. And occasionally you might be lucky and get one question repeating. So sometimes they do repeat, but that should not be the reason why we are going through this. This is just to familiarize yourself with how to go about answering the questions. So question 2. In relation to professional ethics for corporation secretaries, explain 5 instances which might be considered to be professional misconduct. In relation to professional ethics for corporation secretaries, explain. This is a question that is directly related to this, the CS people. CS is corporate secretaries. So in relation to professional ethics for corporation secretaries, explain 5 instances which might be considered to be professional misconduct. Now, when I was checking this question, I felt like doing some more research on this question. And the best place where I could get this was to go right to there's an Institute of Certified Secretaries, and get to see how they define professional misconduct, because it's all about them. Institute of Certified Secretary, it's a professional body. So if I want to know the instances which might be considered professional misconduct, the best way is to go right into their rules and get how they define or the instances that might be considered professional misconduct. So let's go back there where I went so that you can see for yourselves. We just pick what is of concern to us. So here we go. Here we go. Here we go. Here we go. Good. So this is a professional misconduct, and I hope you can get to see what I'm seeing. This is under Section 9 of the Companies Secretaries Act 1980, the Council of the Institute. Now, there are quite a number of this definition of professional misconduct here, and all these are part of the misconducts. Professional misconduct in relation to company secretaries in practice, professional misconduct in relation to members of the institute in service, professional or misconduct in relation to members of the institute generally, other misconduct in relation to members. I think all these are professional misconducts. Our concern is on let's just pick any here. A company secretary in practice shall be deemed to be guilty of professional misconduct if he, now all these are now points. Number 1, allows any person to practice in his name as a company secretary, and that person, unless such a person is also a company secretary in practice and in partnership with him or employed by him. So if you allow another person to practice in your name, and that person is not licensed to practice under that name, then that is professional misconduct. I think that goes without saying. If you allow any person to practice in your name as a company secretary, and that person is not registered as being in partnership or employed by you, then that is considered professional misconduct. I hope you're writing down. I will not be writing this. If you allow another person who is not a company secretary, not working under you, not in partnership with you, to use your name to do that business, that is professional misconduct. When you pay or allow or agree to pay or allow directly or indirectly any share, commission, or brokerage in fees or profits of professional business to any person other than a member of the institute. Yeah, makes a lot of sense. When you accept or agree to accept any part of the profits of the professional work of a person who is not a member of the institute. Basically, what this is saying is that you need to guard on that license that you have. You should only work with partners or allow partners to work with you, or somebody who is under your strict instructions. You can see when you accept a position as a company secretary in practice previously held by another company secretary in practice without communicating with that other previous secretary, that is also considered professional misconduct. I think we can get so many answers here. What you need to do, just pause, read all this, and all these are answers. Number 2, a member of the institute shall be deemed to be guilty of professional misconduct if, being an employee of the company, pays or allows or agrees to pay directly or indirectly any person in the emoluments of the employment undertaken by him. I think the bottom line is that you have been given the license. You are supposed to make sure that that license is actually put into the right use, and it's only the professionals who use that license. Otherwise, if you allow anybody else to use that license in other ways, that is professional misconduct. Then another one, if you are not a fellow of the institute and you act as a fellow of the institute, that is professional misconduct. Now the question wanted us to do what? Let's come back to the question. In relation to professional ethics, explain 5 instances which might be considered to be professional misconduct. So let's go back again. Other misconduct in relation to members of the institute generally. If you are guilty of any civil or criminal court for an offense which is punishable for a term not exceeding 6 months. So if you are liable for any civil or criminal in a civil or criminal court for a term not for an offense which is punishable with imprisonment, then in such like cases, again, that is professional misconduct. In the opinion of the council, you bring disrepute to the profession. That's also misconduct. If you disclose information acquired in the course of professional engagement, that is misconduct. Disclose information acquired in the course of professional engagement, of course, against the wish of your client. If you certify or submit in your name a report of an examination on the matter relating to the company secretarial practice and related statements, unless the examination of the same statements have been made by you. So if you just sign in issues that you are not so sure, you've not even gone through them, that's professional misconduct. You don't know what it entails and you sign. That is professional misconduct. If you permit your name or your firm to be used in connection with a report or statement contingent upon future transactions in a manner which may lead to belief that you vouch for the accuracy of the forecast. If you allow somebody to misuse the name of your company and possibly he relies on that information, the client or stakeholders rely on that information, that is professional misconduct. If you fail to disclose material facts, if you fail to report material misstatements known to you, if you do not exercise due diligence, or you are grossly negligent, if you fail to obtain sufficient information necessary for expression of opinion, if you fail to invite attention of any material departure from generally accepted procedure, all these, they really make a lot of sense. If you contravene the provisions of the Act, I think these are so many points. If you embezzle money received in professional capacity, that is professional misconduct. You embezzle money received in professional capacity. If you disclose confidential information acquired in the course of employment, I think this one we've talked about, but you can always repeat. If held guilty by any civil or criminal case for an offense which is punishable with imprisonment for a term exceeding 6 months, I think we've talked about this. So there are so many points here. You can just pause and then get to read all these points. Just pause, read all these points. So many points. This will help you answer that question well. And the examiner only wanted, I think it was a bit lenient, he only wanted 5 instances which might be considered professional misconduct. And you have so many. Do you need me to write them here? Can we write again? Do you really need to write? Okay. If you say so, then we might need to write. But let's just pick any 5. Let's just pick any 5 or 6. We've said offense that will lead to civil or criminal cases in court of law. Cases in court of law. We've said divulging confidential information in the course of professional duty. Then we've also talked of allowing another person to use your credentials, allowing another person who is not qualified to use your credentials to satisfy or something, do something that might raise the public, that the public might depend on. Then we've also said when you don't, act, the duty of care, when you don't act, this the person in you, the professionalism in you, where you act negligently, and through that negligent action, people can end up in, making uninformed, wrong decisions. Then we've also talked of failure to disclose material facts. Failure to disclose material facts. Failure to disclose material facts or misrepresentation or misrepresentations. Then, of course, we've talked of embezzlement and fraud, being involved in embezzlement and fraud cases in the course of doing your job. Then, there are quite a number. I think just go back there and read. These are just a summary, but you have seen we have more than 15. So, let's move to the next question. In the context of solving disputes through alternative dispute resolution, explain 4 advantages of traditional dispute resolution mechanism. Traditional dispute resolution mechanism. Now, these ones are always preferred because in most of the time, courts have a backlog of cases. So it will take forever to just get your case, be heard and to completion. So normally, traditional dispute resolution mechanism are faster. They are flexible. You can organize where to meet, when to meet. They are you participate in the selection of the judges who to hear your case. Selection of judges, and this can lead to people who understand you better. You can pick people who understand you and the situation better. Then you are free to select your judges. Then, of course, it's fast, or we talked about fast. We can also talk of less expensive. It's less expensive compared to the court cases, which, of course, you have to have legal people. There's a lot of legal jargon that goes on, and you have to have those learned people coming in to stand in for you. Others may not understand anything. So it's less expensive because, again, the other advantage is that here, it's not really, these people don't really, they don't have to rely 100% on the laws. At least they have some room for flexibility, just like we've said. And there are quite so many other advantages which I would like us also to share from my research. We have quite a number of advantages and disadvantages. You might want to do a pause here so that you get all these advantages. Plus disadvantages, what has not even been asked, because the next question might be asking about the disadvantages. So, speedy and informal resolution of disputes. I think we've talked about that. Confidentiality. This is very nice. It's a point, confidentiality and avoidance of publicity. In court cases, it's public. Anybody can go, you can attend. And, for alternative dispute resolution, you can choose a venue and just the parties who are affected to come, and even the award is not made public, it's just for your consumption. But that confidentiality is good when you go the alternative dispute resolution way. It improves communication, preserving or enhancing relationship between parties. Courts might, in most cases, courts don't care, even if you are neighbors, so long as there is fairness. But what the test that remains between you and your neighbor, the court may not care. For them, it's just about fairness and justice. But even if your relationship is now will be damaged beyond repair, that is none of their business, so long as fairness, according to them, has been served. So for this one, alternative dispute resolution, they care the relationship afterwards. So it's quite a better way of resolving disputes as opposed to courts. High degree of party control. We said that you can own the process. You can even choose the judges who will preside over your case. Flexibility, we talked about that one. Legal or other standards of fairness. Remember, we said you really don't have to stick to the legal, and you can see this is supporting that. Even other standards of fairness can be used in crafting agreements. Yeah, I think those ones are good enough. Increased satisfaction and compliance, we talked about this. So all these are advantages. What else can I give you? These are more than what the question wants. So let's go back to the question. The question is only interested in 4. You have around 8. Okay. Let's move to the next one. Summarize 6 grounds. Summarize 6 grounds for setting aside a tribunal award. Sorry, not a tribunal, an arbitral award. So it has already 6 grounds of setting aside arbitral award. So number 1, when you have the award is ultra vires, acted ultra vires. It has exceeded its powers. Its powers. When you exceed the powers or the scope or your jurisdiction, when you exceed your jurisdiction, you go beyond what was expected of you, then that can be as a ground for setting aside an arbitral award. It has been awarded, but now we don't follow it again because you have exceeded the powers, you have exceeded the jurisdiction, the powers that are vested on you, so you've acted outside the scope. That can be a ground for setting aside an arbitral award. When the capacity of the parties is questioned, capacity of the parties in question is questioned. When you have incapacity, for example, if one of the parties to this whatever award is incapacitated, that is either a minor or a drunkard or insane. You know, these are questions that can always rise again. And if it's found out that any of the parties was in any of these conditions, insane, drunkard, minor, you know, and it basically qualifies, then in such a case, that can be a ground for setting aside an arbitral award. So capacity or incapacity of the parties in question can be basis for setting aside an arbitral award. Unlawful agreement. Unlawful agreement. When the contract in itself, contract or the agreement is illegal. The agreement is illegal. You come up with an agreement that is illegal, or the contract that you are seeking an award basically is illegal in the first place. So you have been given an award, but the contract is illegal, or the agreement is illegal. So in such like cases, it cannot hold water because the premises under which the judgment has been passed or the award has been awarded to you are illegal. It cannot hold water. So if you're talking about unlawful contracts or unlawful agreements, that could be a basis for arbitral, for setting aside, that is thwarting the arbitral award. Then no notice, lack of notice to the other party, lack of notice, sufficient, lack of sufficient notice, or lack of notice completely to the other party. Generally, there should be enough notice to the other party to enable preparation. But if you don't give the other party enough notice, so that is sufficient notice, or you completely don't give him notice, then in such like cases, the award might be set aside. There should be enough notice, and this also goes a long way as part of being this what we call the natural justice. Some of the key items when we talk about natural justice is to give the other party enough time to prepare for the case or the proceedings that are before him. Then we also have when you form a tribunal, that that the parties are not in agreement with, that is, you disagree on the composition of the tribunal. When the other party feels that there's a bias or there is some favorism that is going to arise as a result of the tribunal which has been formed just from the composition, then in such like cases, that can be a ground for setting aside an arbitral award when the tribunal does not meet the test or the agreement of the parties involved. So when you form a tribunal that the parties are not in agreement with, that could be a ground for setting aside an arbitral award. When the award is also in conflict, is in conflict with the public policy, or it brings about disrepute to the public, then we say that award might also be set aside if it's not in line with the general thinking or with the policies that have been set by the country. Then in such like cases, we say, or it's in disagreement with the ethical standards that have been set by the country, then in such like cases, it might be set aside. So how many points are these? These are 6 points. I think these are good to go. So any of these points will be able to give you a mark. Any of those points will be able to give you a mark. So thank you. Let's meet in the next question number 3. Thank you so much.